Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to this week's episode of Winning Isn't Easy. Before we get started, the Florida Bar says I have to give you a legal disclaimer that says this podcast isn't legal advice. Nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Do you have ME/CFS or fibromyalgia? Now, I talk a lot about ME/CFS and fibromyalgia claims because I think that they are the trickiest cases to win. In this episode, I'm going to talk about three topics. But I want you to understand that even though I'm talking about ME/CFS, it doesn't mean that these topics aren't relevant to other diseases because disability carriers will generally play out of the same playbook. Topic 1, is a diagnosis of fibromyalgia sufficient to overcome an Aetna disability insurance claim denial? 2, chronic fatigue syndrome disability insurance claims and what you need to know about limited disability benefit clauses. And fibromyalgia and objective medical evidence. Hartford challenges a 20-year claim. Ready to take a break before we jump into this week's episode? Let's do it.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at kvlaw.com today.
Welcome back to Winning Isn't Easy. Is a diagnosis of fibromyalgia sufficient to overcome an Aetna claim insurance denial? Let's start out with some basics. You, as the disabled policyholder or beneficiary, have the burden to prove your entitlement to benefits. Is diagnosis alone sufficient to meet your burden of proof? So let's talk about this case in the context of Boatwright versus Aetna Life. This is a Middle District case out of Florida, and Ms. Boatwright was diagnosed with a number of medical conditions, including fibromyalgia. She applied for and she was paid her own occupation long-term disability benefits by Aetna until the definition of the disability changed to an any reasonable occupation test. At that point, Aetna denied her claim based on the lack of current medical information from her treating physicians, the result of 3 liar-for-hire peer-review doctors who had looked at her records, a vocational report that said she could work, and surveillance. Now guess what? Her case ended up in federal court. And she tried to overcome her lack of medical evidence by arguing that the diagnosis, the lack of improvement over time, and the fact that there's no known cure for fibromyalgia was sufficient to win the day. Unfortunately, but predictably, the judge disagreed, noting that the diagnosis of a condition or conditions is insufficient to establish that a plaintiff meets the definition of disability within the meaning of the policy of the plan. Now, the judge correctly pointed out that the issue before the plan administrator was whether the fibromyalgia precluded her from working in any reasonable occupation. So it wasn't the diagnosis that was at issue, it was whether or not she had restrictions and limitations that would prevent her from doing any reasonable occupation, as that term is defined in the policy. I think there's some lessons to be learned from this case. The case was lost primarily because of the lack of proof. So we need to understand first that the diagnosis alone isn't sufficient. 2, that you've got the burden to prove and your case, and you've got to provide medical information about your symptoms, how those symptoms impact your ability to work in any reasonable occupation, the objective basis for those restrictions and limitations that impact the ability to work. And to do that, number 3, you should be undergoing what's called a functional capacity evaluation, which is an objective measure of your physical capabilities, or a CPET study to document the impact of fatigue on your ability to work. If your doctor isn't supportive, then you need to find a new doctor. And the 4th tip is not only do you need to find a new doctor, but potentially you should undergo your own independent medical evaluation by a physician who understands the nature of this disease and is competent and qualified to render opinions based on a physical examination and review of your records about your diagnosis and your restrictions and limitations. And number 5, you should be obtaining a vocational evaluation, because you'll need to tie it all together. You need to establish not only that objectively you have restrictions and limitations, but that these restrictions and limitations are such that you couldn't perform any reasonable occupation, or depending on the definition, any other occupation in the that you could perform potentially based on your education, training, experience, and skills that you've learned. Got it? Please, please don't let these mistakes doom your claim. You need the assistance of an experienced ERISA disability attorney in these claims, simply because these are the kinds of claims that disability carriers hate and they love to deny. So don't give the disability carrier a reason to deny your claim. Let's take a break.